We thank the parties for their submissions. Our decision on this application is as follows. Firstly, in relation to ground 1 as proposed, which says that the High Court was wrong to find that the unborn do not have the right to life or to protection from inhuman treatment. The High Court found that the European Court of Human Rights has never decided that the unborn are bearers of convention rights, but has instead left that controversial and difficult issue of when life begins to the judgment of each state. It said that our domestic law has not and does not have to go beyond that. Mr. Koppel argues that the European and English cases do not in fact make that clear. He says that English law can be seen to recognize and protect the interests of the unborn, for example, by making child destruction an offence, or by giving a right to sue for pre-birth injuries. I do not consider that this ground of appeal has any chance of success. The High Court has stated English law as it is clearly understood to be, and there is no arguable case that it is incompatible with the Convention in this respect. The applicants want to change the law, but any change of that kind is quite clearly a matter for Parliament. Nor, in my view, is there a compelling reason for an appeal to be heard on this issue. I would therefore refuse permission to appeal on this ground. I next turn to grounds 2 and 3, which say that the High Court was wrong to find that the Abortion Act does not interfere with Article 8 or Article 8 read with Article 14, respect for private life and discrimination. Ms. Smith, for the Secretary of State, says that the court took account of the evidence when coming to this conclusion, and that it's academic anyhow, as it found that any interference with rights would be justified and proportionate. The remaining grounds of appeal, numbers 4 and 5, challenge those further findings. As to these grounds, firstly, I would refuse permission to appeal to Miss Lee Wilson in her own right. Her complaint that she felt under pressure to terminate her pregnancy is, as the High Court said, a complaint that guidance was not followed. Even if it was not an isolated instance, it is not a basis for a finding that the law is incompatible with the Convention. Secondly, I would not grant permission to Miss Crowter and Aidan on these 4 grounds, on the basis that an appeal would have a real chance of success. For what it is worth, I do not consider that the High Court's conclusions on justification, ground 4, or proportionality, ground 5 to be arguably wrong. So if that is so, an appeal would fail regardless of the outcome on grounds 2 and 3. Thirdly, however, I would grant permission to appeal to Miss Crowter and to Aidan, with his mother acting as his litigation friend, on these grounds 2 to 5, because I consider that there is a compelling reason for the full court to consider the issues raised by these grounds. My reasons are, firstly, that although it appears that the court may have accepted that Article 8 rights are held by Heidi and Aidan in these circumstances, it is at least arguable that the treatment of the question of interference, in particular at paragraph 102 of the High Court's judgment, was not adequate. And secondly, that even if the appeal is likely to fail for other reasons, this is an area where clarity is important, and the applicants and others in their position are entitled to know where the law stands on the question of their rights and whether they have been interfered with. Lastly, since we are granting permission to appeal on these specific and reduced grounds, I would admit the statement from MENCAP at the hearing of the appeal. It does not meet the normal criteria for admissibility, and it may do no more than trace the same contours as the existing evidence. But it is likely that this court would admit this kind of material had the organisation applied to intervene after the grant of permission to appeal. I would therefore grant permission to appeal on those specific and reduced grounds.
I agree.
Yes, Mr. Coppell, we need to see what, if any, directions can usefully be given now to arrange for the hearing of the appeal.
Yes. Well, there's one practical matter which Mr. Conrad, my solicitor, has asked me to raise immediately, which is that we have a cost capping order in place in relation to the proceedings.
Date of that order?
Sorry, my lord.
So the date of that order was what?
So it is the 12th of October 2020, and it was made when permission was granted by Mr. Justice Morris. As we understand the order, it applies to the proceedings. So it's on page 144 of the core bundle, which you may or may not have access to. Our understanding is that it would extend to the proceedings also on appeal, but if the Secretary of State wishes to contend otherwise, then we need to know.
I obviously haven't yet discuss this with my lady, but is this a matter that is best first discussed between the parties? And if agreement can't be reached, then whether it's a question of an application or whether it's a question of clarification of something that exists, because I'm not sure that when people agree cost capping orders, they're intended to include any which stage afterwards, and that needs to be dealt with. That this is something that ought to be timetabled, if not agreed, for an application fairly soon.
Yes.
It can be made to either my lady or myself as we are dealing with directions at this stage.
Thank you. Well, I will take that forward.
All right. So I'll make a note that costs capping remains to be decided.
Then, so far as practical steps that we would have to take, we'll need to amend our grounds and amend our skeleton arguments.
Do you need to do that? I mean, essentially, it amounts to no more than ignoring the parts that. I mean, if Ms. Smith would prefer to have a clean document, then I'll hear from her. But
it's a very detailed skeleton argument in any event, so I'm not sure it really does require.
yes, I don't think we want to multiply documents, and I think essentially you've put your case, and it's there, and there are clearly paragraphs that can be blue-lined. Right. So I think the two things that we had considered were firstly what the likely length of hearing is, and secondly that we obviously need to invite the Secretary of State to give us a date for his skeleton argument in response.
Yes. So far as the length of hearing is concerned, I would ask for a 1.5 day hearing. I appreciate that is essentially what we had before the divisional court, and we now have less.
I think we think a day. Unless, I mean, perfectly happy to hear you about that, but I think we've now got a sense of the scope of the issues.
Lord, I would ask that a day and a half be allowed. These reasons. I mean, what is left is interference with Article 8(1) rights in accordance with the law, proportionality, but there are a number of quite complex issues which involve a fairly wide.
All right, we'll put our heads together in a moment and see what we think about that once we've heard from you both. A day or a day and a half? Yes.
I'm being reminded that there may be applications to intervene, but.
Well, I know. I rather thought that would be the time to extend the time estimate, rather than setting aside empty ground for people to apply into. But anyway.
Well, I asked for a day and a half at this stage because thinking of the practicalities of getting my opening submissions done in a morning, which cover the relatively wide range of issues.
We have the point, and can I just say this? Obviously, it's a case in which there might be applications to intervene, but insofar as the various points of view are very competently represented already, I don't think organisations should consider that simply because they have an interest they're likely to be given permission to intervene. The court will want to ensure that the bases are covered, but will not be anxious to multiply participants, because of course as soon as one has one participant, then somebody wants another participant by way of, quote, balance and so forth. So let me leave that hanging in the air.
Can I just also say this? It's only on limited grounds that permission has been given, and speaking for myself, I would be concerned that there is a focus to the full hearing, and that focus can be dealt with firstly in writing, and you have written extensively in your skeleton argument, and therefore it can then be translated into the oral submissions to the court. I don't think we should lose sight of focus, Mr. Copple.
Any other
Not
matters? No. Thank you very much. Ms. Smith. By all means. Right. Well, you'll put a date on that. Do you have any views on the question of length of hearing?
I'm so sorry, my lord.
I beg your pardon. Did you have any views on length of hearing?
We will submit a day is sufficient.
Right. All right. 1 day. Good. Could we kindly invite you to draw up an order reflecting all of that? And I hope that I identified precisely what is and what isn't on the menu, so that anybody coming to this afresh will be quite clear as to what our decision has been. All right. Thank you very much indeed.
Got Rise?